Hey all, Glenn Kirshner here. So friends, this morning I attended the arraignment in the criminal case of the United States of America versus James Comey, the former director of the FBI, the former U.S. attorney for the Southern District of New York, a former high DOJ official. And whereas it's a really dark day for the rule of law, it's a really dark day for the nation because by all accounts, this is nothing more than a vindictive prosecution brought by a revenge-fueled president of the United States. But I hope when history records what happened on this day, it actually is a point of light, because I have a feeling this prosecution will fall apart spectacularly. And what will that prove? That will prove that Donald Trump is a paper tiger. He is forever promising that he's going to prosecute his enemies. You know, for nearly 10 years, we've been hearing lock her up, lock her up. He's going to prosecute Hillary Clinton. Hillary Clinton hadn't been prosecuted for so much as a traffic ticket. And Donald Trump has added dozens and dozens of enemies to his enemies list. The first one, he had one of his attorneys, one of his, unqualified U.S. attorneys, Lindsay Halligan, actually indict as James Comey. And today, James Comey was presented in court at his arraignment. And I was in the courtroom, and what I did was I jumped onto Substack, my Substack page. I would invite you to come on over to Substack and subscribe, which you can do for free. You can pay to support my efforts, but you don't have to. I don't put anything behind a paywall on Substack. I jumped on Substack, and while it was all fresh, what went on inside that courtroom, I wanted to get it all on video. So what I'm doing now is I'm going to post as today's Justice Matters video my Substack recounting of what went on in that courtroom today. I managed to get into the courtroom proper. It was broadcast into overflow courtrooms, but I was in the actual courtroom with Comey, with Lindsay Halligan, and the prosecutors, with the judge, and with the folks in the audience. And I'm going to try to do my best to kind of bring to you everything that happened in that courtroom and talk about what it means, what it may mean moving forward. The only caveat is that as I was recording on Substack, I forgot to put my earbuds in, so you'll hear the first half of the video. The sound quality is not great. You can make out what I'm saying, but it sounds like I'm talking with a lisp. It's okay. And then you'll see when I put my earbuds in, the sound gets appreciably better. So, with all of those caveats and qualifications, here is my take on what I saw inside the Comey arraignment courtroom today. Good afternoon, everyone. I am not going to say happy James Comey arraignment day because there was nothing happy about it. This was a dark day in our nation's history. It was a dark day for the Department of Justice. It's a dark day for our criminal courts. You know, there was no lightness to any of this. But as I said when I was on with Jim Acosta, I had the pleasure of being on live with Jim Acosta, who really is the pinnacle of independent journalism, reporting, and media now. So I jumped on with him from the courthouse live, both right before the hearing and again right after the hearing. I was on with a couple of my friends, Miles Taylor and Olivia Troy. And let me tell you, it is so gratifying to be able to go right to you all, our friends here on Substack, and it was simulcast elsewhere by Jim, YouTube, and I think other platforms. And to be able to give you the real, unadulterated, unfiltered, not edited, no corporate money or corporate interference. I'm already getting on my independent media high horse. Sorry, that's not how I intended this part, but it was really good to be able to do that. Hello, Dean. So here's what I want to do. I want to take you through what happened in the courtroom.
And then we're going to talk a little bit about the atmospherics, about what the atmosphere was like outside the courtroom and what it was like waiting for the proceedings to start. But Jim Comey, former FBI director and avowed enemy of Donald Trump's, was arraigned on 2 felony charges today. An arraignment is typically the first court hearing that a defendant will have after he or she has been indicted, and arraignments usually last 5 minutes. This one lasted about 25 minutes. There were some in-depth discussions that ordinarily don't go on at arraignment hearings. So let me just take you through chronologically what happened, okay? First of all, there were 3 federal prosecutors at the prosecution table. Lindsay Halligan, who didn't say a word, she was a potted plant. Remember, she is the one that Donald Trump installed as acting U.S. attorney in that office so she could sprint into the grand jury and obtain an indictment that, as best we can tell, there is not enough evidence to support. We don't know what she did inside that grand jury, but we may find out and put a pin in that. She didn't say a word, you know. I'm just going to stop there. I'm not going to talk anymore about Lindsay Halligan. There were 2 other prosecutors. This is really interesting. These are 2 apparently assistant U.S. attorneys down in, I think, the Eastern District of North Carolina U.S. Attorney's Office. Guys, these 2 guys are named Nathaniel T. Lemons and Gabriel J. Diaz. Nathaniel Lemons, yes, like, sucking on a lemon. Nathaniel Lemons was the only one who spoke for the prosecution. The other 2 didn't. And I couldn't find much about Nathaniel Lemons online. Very, very little. It was a picture of him as a former Marine. I believe it was him. It was the same name with the same middle initial, I believe. But, we'll do some research and figure out more about who in the world these other 2 prosecutors are that are willing to go on what I consider a suicide mission, legally speaking, a suicide mission, because they are undoubtedly putting their license to practice law, their bar license on the line by plugging into this vindictive prosecution, in my opinion. So, and then there were 2 defense attorneys at Jim Comey's defense table. They are Patrick Fitzgerald, who is a former U.S. attorney, very high out in Chicago, has done lots of high-profile prosecutions, very highly regarded, very well respected, typically on both sides of the aisle, respected by all, served, I believe, in both Republican administrations and Democrat administrations. So he is somebody who is really a marquee attorney representing James Comey. And I'm going to tell you how Patrick Fitzgerald first addressed the court in a minute, because I found it not just surprising, but unprecedented in my experience. But here's the thing. There's another defense attorney on Comey's team. Her name is Jessica Carmichael. I hadn't heard of her before, but I looked a little bit online and talked to some other folks who were familiar with her work. She's a very accomplished and well-respected criminal defense attorney, I believe previously a federal public defender, who has done many cases in that courthouse involving things like classified information and potentially national security related cases. And we're going to talk more about that in a minute. We're putting a lot of pins in things right now, but I want to go through chronologically. So those are the parties. And it's Judge Michael Nachmanoff is the judge who has been on the bench there for quite a while. And he certainly came across as a very serious, no nonsense, I don't want to say stern, but judge who is committed to moving this case through the system efficiently. The Eastern District of Virginia, that court is known as the Rocket Docket. Why? Because they push cases through the system extremely quickly, and they don't put up with delays, not from the government, the prosecutors, and not from the defense. They move cases through, and the judge said a few things about that, if that's not the 4th pin we're putting in it while we work through this chronologically. So the first thing that happens at an arraignment is the defendant is put on notice of the charges in the indictment. So he knows what he will have to defend against. Now, ordinarily, the court will ask the defense, do you want the court to read the indictment, or are you willing to waive formal reading of the charges? And of course, James Comey waived formal reading of the charges. So after he was put on notice that there are two charges, two felony charges on which he's been indicted. One is false statements. It's a lot like perjury. When you lie to Congress, it's charged as a false statement under federal statute, United States Code, Title 18, Section 1001A2, for those of you scoring at home. It's a 5-year offense, and it carries up to $250,000 in potential fines. And the second charge is obstruction of Congress, obstructing a congressional proceeding. They're kind of double dipping here, right? They're not, it's not prohibited to double dip when you have an element of one offense that is not an element of the other offense. I think that's called the Blockberger test. I'm thinking back to my prosecutorial days. So, but basically it's the same conduct. They say you lie, which is a violation of 1001, and that lie obstructed a congressional proceeding, which is the second charge for the identical conduct. And that is under 18 United States Code, Section 1505. So those are the two charges. Each carries a 5-year maximum prison term. Of course, the voluntary sentencing guidelines would come in well below. These would be probation eligible crimes if he was convicted at trial, which I don't think he will be. And they each carry up to $250,000 in fines. So then Patrick Fitzgerald addressed the court. He said, Your Honor, Patrick Fitzgerald, and it is the honor of my life to represent James Comey. I mean, he wanted to set the tone. I've never heard a defense attorney introduce himself to the court like that at an arraignment, saying it's the honor of my life to represent this client. Now, I've often had defense attorneys say after they announce their name, and it's my honor to represent defendant John Smith, or, I am honored to represent defendant Susan Jones. That's not unusual. But it is the honor of my life to represent James Comey. That was an interesting way to open, and it set a tone. I will say then, James Comey stepped to the podium, and, he is a very tall man, and I would say he towered over the proceedings today, both literally and figuratively. He's such a highly accomplished person. The many roles that he has played: U.S. Attorney for the Southern District of New York, the Director of the FBI. I think he was I don't remember if he was the Deputy Attorney General or the Chief of the Criminal Division at DOJ. I forget the precise titles. But, unfortunately, one of the reasons we all remember him now is because of what he did that was improper and inappropriate in the run-up to the election between Donald Trump and Hillary Clinton. He did something that ran contrary to the policies and the norms and traditions that we all operated under at the Department of Justice, which includes the FBI. You don't talk about matters in the 60-day run-up to an election that could impact the election or could belie some sort of partisanship. He decided to do it. I believe he was wrong. I think there's also a strong argument that it was well-intentioned. He thought it was the right thing to do to preserve the public's perception of the FBI. I don't want to relitigate all that, but the reason I bring that up now is I covered a lot of trials over the last 5, 6, 7 years, mainly across the river from where we were in the Alexandria U.S. Attorney's Office and Courthouse over in D.C. I covered the Oath Keepers and the Proud Boys and Roger Stone and Steve Bannon. And all of those, and I was at the Trump arraignment when he was arraigned on the criminal indictment for trying to overturn the results of the 2020 election. All of those garnered lots of public interest and attention. But today, there were more members of the media than there were members of the public there. It didn't really garner the kind of attention from folks who are not, media or media adjacent or interested in it for just because they're, there wasn't a whole lot of general public folks there. There were some, and I got to chat with a lot of people, but it was not as well attended as so many of the other prosecutions in the Trump era that unfolded in the DC federal district court, for what that's worth. There were protesters, there were signs. I'll post some pictures of all that when I'm done this video. So after he said he was pleading not guilty, the judge then asked if what they wanted the trial date to be. Now, a little bit of inside baseball. I was listening when Patrick Fitzgerald was asked if he wanted a speedy trial, and he said, "We're demanding a jury trial." He omitted the word speedy, which is interesting but not surprising. If he had demanded a speedy trial, this trial would have had to been conducted. The jury would have been had to be sworn by December 17th. That's a speedy trial, right? Here we are almost halfway through October, November, December, 2 months. So he didn't ask for a speedy trial. He asked for a jury trial. And both the defense and the prosecution agreed that neither one of them were interested in pushing this to a speedy trial by December 17th. The judge said, well, I'm a little skeptical because, we move things along here. He didn't call himself the rocket docket, but that's what this court is known as, the rocket docket, moving very quickly through litigation. But he said, I'm not going to force the parties to go to trial before they believe they can be ready. So he didn't stick to the December 17 speedy trial date. That's when the speedy trial clock would expire. He let the parties push it out a little bit further, but I mean only a little bit. So the next thing they turned to were motions. What motions does the defense intend to file? And this is where Patrick Fitzgerald really got going. And he was very understated, very respectful, didn't come across like a showman. But here are some of the motions he told the judge that the defense team would be filing. They said they would be filing a vindictive prosecution motion. And as part of that, they would also be arguing that it was a selective prosecution. He would be filing a motion claiming this was retaliation brought at the direction of Donald Trump. And I think he said to silence James Comey. The acoustics weren't great in the courtroom, but I think that's what he said. A retaliatory prosecution brought at the direction of Donald Trump to silence James Comey. And I heard shades of the First Amendment right to free speech as part of that motion. He said they will also be filing a motion on the unlawfulness of the appointment as Attorney General of Lindsay Halligan. That is such a hugely consequential motion, because if it turns out that she is not lawfully in the position of acting U.S. Attorney, then this indictment, I believe, would be null and void and would be thrown out, and the case would have already passed the statute of limitations date. So it would get thrown out on that ground alone. So here's what Fitzgerald said. Your Honor, that is our first batch of motions. Those are the motions that we believe may be case dispositive. What does that mean? Translated from legalese to English. If you grant any of these motions, the case gets thrown out and there is no jury trial. So he asked that these motions be taken up very quickly. And he also said, I am requesting that the executive branch, Donald Trump, the DOJ, this prosecution team, provide the documentation that shows Lindsay Halligan's appointment as U.S. Attorney before she sprinted into the grand jury. He didn't say sprinted, but that's what she did within days of being appointed. We want to see the appointment paperwork, because we contend she was not lawfully appointed. And he added, we need that paperwork from the prosecutors, quote, forthwith, meaning right the F now. And here is how short-fused the filing deadline for those case dispositive, those dramatic motions to dismiss will be. He set the deadline for the filing of those motions on October 20th, 12 days from now. I mean, that is some light speed. Now, I have to believe those motions are already largely drafted by the defense team because, man, they look like they're ready to go. They look like they're anxious to get going. And so, yet 12 days from now, we're going to have motions on vindictive prosecution, selective prosecution, illegal appointment of Lindsay Halligan, and retaliatory prosecution at the direction of Donald Trump to silence James Comey. That's going to be some great reading. I can't wait until they hit the public docket 12 days from now. And then maybe we start to see a little bit of justice done. Yeah, I get a little excited. I get the justice goosebumps going. It was really fun to be back in the courtroom. I missed it terribly, but I like to be on the other side of the bar at the prosecutor's table, trying the cases. I'll do that again if we can get the election right, the next presidential election. I hope to be able to do that again. I don't want to make any assumptions. So then they turned to the second batch of motions, the ones that didn't necessarily need to be resolved so quickly. And James Comey said the second batch of motions are going to be motions that include things like, excuse me, the truth is a defense to this allegation that he lied. Sorry, I'm going to have a coughing fit here. Give me a minute. Oh, I hate when that happens. And you all have to suffer through it with me. He's going to file a motion claiming that truth is a defense, which it is. He's going to file a motion for grand jury abuse, and that one's going to be a beauty. And he's going to file a motion for outrageous government conduct. And those motions are due on October 30th, 22 days from now. Again, we're going to move through this litigation at light speed, but we're going to be talking about this a lot in the coming weeks. And then the first oral arguments in the case have been scheduled for November 19th. That is on the dispositive motions to dismiss. And the second, and I have just realized I forgot to even put my earbuds in. Shame on me. Hopefully the sound is a little bit better there. Somebody drop a note and let me know if you can hear me. Can you guys hear me okay? Hopefully. Comey's flamethrowers. Okay, Earl says yes. Thank you. So the second round of oral arguments will be December 9. So we're going to be back in court on November 19th to hear oral arguments on the case dispositive motions, and December 9 for oral arguments on the remaining motions. And then the trial date, I kind of buried the lead, January 5th. That is less than 3 months away, right? Light speed, proving the point that, yeah, the Eastern District of Virginia really is the rocket docket. They move through at light speed. And think about it, the speedy trial date was December 17. So they didn't push it out all that far. 2 weeks, 2.5 weeks from the speedy trial deadline? Yeah, James Comey wants his trial. And I think even more pointedly, he wants his motions to dismiss litigated pronto, because there's a very good chance, friends, that this case gets dismissed because of either Halligan's unlawful appointment, if it was unlawful, vindictive prosecution, or what was the other one? retaliatory prosecution. So that's kind of the nuts and bolts. And then they turn to other matters. Let me kind of tick through a couple other things that went on. They talked about classified information. And I think it was a little bit of a red herring. And here's why I say that. This prosecutor, who I don't think uttered more than about 15 or 20 words the whole time, Nathaniel T. Lemons, we'll see if he turns out to be a lemon of a prosecutor or not. He said, well, Your Honor, there's some classified information involved in this case. And the judge was kind of like, really? Because these do not seem to be complicated charges. And so when you have, and right now the judge doesn't know if these prosecutors are being straight with the court or not, but taking them at their word that, oh, there's going to be some classified information here. The judge said, okay, then you will move through the necessary steps to deal with the classified information right quick. And there are two ways you can move through the procedural steps involved in trying a case that really does legitimately involve classified information. Like, I don't know, if somebody stole a bunch of top them in his bathroom and his ballroom at Mar-a-Lago and refused to give them back and obstructed justice by defying a grand jury subpoena for the return of the classified information you stole when you left the White House and violating our nation's espionage laws. Yes, that case had classified information issues, legitimate ones, because of what who stole and hid out down at Mar-a-Lago. This case, the judge was not, I think the judge said he's a little skeptical. This case may have nothing to do with classified information, but sometimes that's a way to kind of slow everything down. Well, judge, classified information, so there's a lot we have to do. The judge said, yes, there are one of two things you have to do. One, you have to declassify it, so issue resolved and we can move directly to trial, or we have to go through the CIPA procedures, CIPA, Classified Information Protection Act. They can be cumbersome. They can take a while to work through and litigate through, but it can be done quickly. But the first thing that has to be done is the executive branch. Donald Trump's executive branch has to grant security clearances to the defense so it can even have access to this alleged classified information. And the judge noted, well, let's see. Patrick Fitzgerald was a longtime Department of Justice employee, so it should be easy to, get him his security clearance, take care of that. James Comey was a longtime, DOJ employee, and it should be easy to get him his security clearance. So I wouldn't expect any delay from Trump's executive branch. And then the judge said, and Miss Carmichael, that is the other attorney on James Comey's defense team, she has a security clearance because she's handled many cases in this courthouse involving classified information and national security related matters. Boy, my ears perked up because it sounds like Jessica Carmichael, James Comey's other attorney. I can't make a leap to the conclusion that it sounds like she's highly regarded by this judge in this court, but she's certainly experienced in these matters, and she's familiar to this jurisdiction, this court, this judge. That's important. I tried to look up her background, and I'm learning more about it. It looks like she's a very accomplished and highly regarded longtime defense attorney, including, I believe, a federal public defender who's handled some national security matters as a criminal defense lawyer and who seems to be very highly regarded, at least based on the reviews that I've read of her work. And I'll learn more and I'll share that with you moving forward. But what that signals to me is that James Comey has put together a really good defense team to take on Lindsay Halligan, Nathaniel Lemons, and Gabriel Diaz. Maybe they'll all prove to be blockbuster prosecutors, but that's not where I would place my $1 bet. And here is how, before I leave the classified information, SIPA, Classified Information Procedures Act, the judge said, you know what, if you're not willing to declassify anything you claim is important as evidence in this case, and we have to go through the SIPA procedures, here is what Judge Nachmanoff said, quote, "We will go through the fastest SIPA process you have ever seen in your life." That makes my heart sing. Why? Because the judge is laying down the law that there will be no bullshit from either of the parties. There will be no, delay built into this. We will move through this, and this trial is going to start on January 5th. Of course, that is, if it's not dismissed on Comey's motions, even before then. Then the final thing that they took up of substance was pretrial detention. It's funny because I was in the courtroom. It was packed. It was maxed out, and there was an overflow courtroom across the hall where they did a closed circuit broadcast, so folks in the overflow courtroom could see what was going on. I got there early, like 8 a.m., just a couple hours early, because I wanted to get into the courtroom proper. And I had almost kind of forgotten that at the end of any arraignment, you have to take up the possibility of pretrial detention. But it was still kind of jarring when I heard the judge say, "Now, let's turn to the issue of pretrial detention." It's like, oh, that's right. But very quickly, the prosecutors conceded that there's no basis for pretrial detention or setting any kind of conditions. And the judge said, yeah, there is no suggestion nor any need for obviously pretrial detention or for conditions of release, setting a bond, having periodic check-ins with the court, putting an ankle monitor on, GPS monitoring so somebody can't flee. Because obviously James Comey does not present a flight risk or a danger to the community in the event he is on release pending trial rather than locked up pending trial. So that was kind of the last thing that went on of substance. And then let me talk a little bit about the atmospherics. So it was a very solemn affair. Everybody was very quiet, respectful, polite. I will say the court staff, the court security officers were wonderful, helping everybody get through security pretty quickly. I will say outside the courthouse, it wasn't exactly a circus atmosphere, but there were protesters holding signs. There were people speaking out, not getting all that loud, not chanting, but they were, all obviously anti-abuse of the rule of law people, right? I'm not going to say pro-Comey or anti-Trump, though there were some of that. There was some of that in the signs that were being displayed, but these were people who feel strongly about the sanctity of the rule of law and the abuse that is presently being perpetrated by Trump and Pam Bondi and Lindsay Halligan for bringing vindictive prosecution. And as I say, it was really gratifying to get to go on live with Jim Acosta, both before and after the hearing. And we'll be doing more of that in each of these court hearings because I plan on attending every one in the Comey case. And the big one is going to be that first motions deadline, 12 days from now, when we're going to learn more about Comey's motions to dismiss, and then the first hearing in the case, which will be, what did I say? November 19th will be the first oral argument. So these are going to be important days and important developments, not only in this case, but on the rule of law front. Because as I was telling Jim, I said, I'm not prepared to say the rule of law is dead. I was almost ready to call the time of death of the rule of law on the day Comey was vindictively indicted, but I held off. And I'm not even going to say the rule of law is hanging by a thread. I'm going to say the rule of law is in the fight, kind of like we are in the fight. The rule of law is in the fight. It's struggling to survive. And if the rule of law rises up and this case is dismissed based on a vindictive prosecution and or an illegal appointment as U.S. Attorney of Lindsay Halligan, that will breathe a little bit more life into the rule of law. The rule of law is fighting for its life. You know, in this case, in the Letitia James case, where a career prosecutor just said, we do not have probable cause to charge Letitia James with mortgage fraud, and I won't do it. The rule of law is in the fight. It's struggling. You know, it's beaten and bruised and battered and bloody, but it's in the fight. It's not dead. It's not yet hanging by a thread. But we all need to be in the fight as well. And we are, and you are. So that is the reporting and the analysis from inside the Comey courtroom this morning. Thank you for jumping on with me. I will be back about 8:30 tonight. We'll do our community meeting and I'll roll some more thoughts about the Comey arraignment into our discussion this evening. But in the meantime, have a great rest of your Wednesday. And I hope to see you all tonight at 8:30 Eastern Time.